I disagree respectfully with my colleague's suggestion that Marbury isn't the natural interpretation of the text of Article 3. Article 3, which gives the power to the courts to decide cases and controversies. The central holding of Marbury, to which he's referring, is the notion that it's emphatically the province of the judicial branch to say what the law is. That is, to interpret the law where necessary to decide cases and controversies. As to suggestions about corporations, New York Times v. Sullivan involved a corporation. No one suggested in that case that there were no First Amendment rights at issue because of the corporate form of the speaker, the publisher, the press agent there. As to the suggestion that judicial philosophy doesn't matter, it does. When I ask that question, I'm not looking for any particular answer, but I do want, more than any particular answer or label, a description of how a particular nominee might go about deciding cases and controversies. When asked to construe a provision of the U.S. Code, of the U.S. Constitution, or some other provision of law, I want to know how he or she might go about it. Justice Montgomery Reeves, I'd like to start with you. You previously served as the Vice Chancellor on the Delaware Court of Chancery. Now, Delaware is one of the few states that's maintained the distinction between law and equity, courts of law, courts of equity. Most other jurisdictions have fused the two so that the same judicial officers are responsible for overseeing legal remedies and equitable remedies. As a veteran and a graduate of that system, and I care to note here, you've both been nominated for the Third Circuit, court near and dear to my heart because I served as a law clerk there previously. As a veteran and graduate of that system where you were a vice chancellor, is that a form that you would recommend to other jurisdictions, including possibly the United States? Did most jurisdictions in the United States make a mistake when we fused law and equity?
Thank you so much for the question, Senator. I don't have a view on whether or not other jurisdictions made a mistake when they fused law and equity. Certainly Delaware does it differently, and as you said, I was in the court that is the Court of Equity. But in my view, the focus as a judicial officer, whether I am a judicial officer in the Court of Chancery as I've been, or on the Supreme Court, Delaware Supreme Court as I currently am, or if I'm so lucky to be confirmed on the Third Circuit, is simply ensuring that I approach every case with an open mind, and that the litigants in front of me are treated fairly and impartially, and that I decide cases based on the law and the facts of the case.
Right. Yeah, well said. And I don't have any particular opinion on it, but I do note there are reasons why a lot of our country's corporation law points to Delaware, because a lot of corporations, disproportionate share of them, hugely disproportionate share of them, are incorporated in Delaware. And I think one of the reasons for that has to do with the fact that in addition to having laws favorable to corporations, Delaware has a good legal, good judicial system. And so they approach that with confidence. And as a result of that, Delaware ends up having a disproportionate influence on laws pertaining to corporations. You were recently asked whether courts could extend the rationale and the ruling in Re Caremark International versus derivative litigation. This was a case, of course, dealing with the duty of care that a corporation's directors have to oversee company activities regarding environmental and social issues. You responded to the question by saying that the case is, quote, enabling in nature, and that it provides, quote, the ability to address evolving business challenges and expectations of their shareholders, close quote. Is it consistent with the protections of the First Amendment for the government to impose on a corporation director a duty of care over social issues, environmental issues, and social policy?
Can you repeat the question for me, Senator?
Yeah, so relating back to an answer that you provided, I believe this was at a symposium where a student asked you about this Caremark International case and asked you what you thought about it and whether that case can properly be interpreted to impose a duty of care to oversee corporate activities regarding social issues, and environmental issues. And you said it was enabling in nature. So is that how you understand that? And if so, is that consistent with the First Amendment to require that?
What I was talking about when I said that, when I was talking about enabling in nature, I was generally talking about the DGCL, the Delaware General Corporation Law, our statute, and talking about that being broadly enabling in nature.
Great. Thank you. See, my time's expired. Thank you, Mr. Chairman.
Thanks, Senator Lee. Senator Coons.
Thank you, Chairman Durbin.